This is Craig Penglase from Overwatch Armaments, and this is Meet the Pressers.
Meet the Pressers with Matt Mallory and Klint and Craig. Brought to you by Public Safety and Education and the Trigger Pressers Union.
Meet the Pressers is brought to you by Mantis. Mantis X helps shooters suck less. Next Level Training, makers of CERT training products. Meet the Pressers is also brought to you by these fine companies, shows, organizations, and our Patreon members. Thank you.
Hey everybody, Matt Mallory here with Meet the Pressers and my awesome co-host, Klint Macro. And we have a very special guest today, but before we get into that and Klint introduces them, we just want to remind everybody what the show's about. We're about guns, gear, gadgets, political activism, faith, pretty much anything that revolves around pressing the trigger and the Second Amendment. So without further ado, Klint, take it away.
I'm very honored and privileged to be able to introduce our special guest. Craig Penglase is one of Pennsylvania's preeminent Second Amendment attorneys, criminal defense attorneys. But he's also a fantastic educator and instructor, and I'm proud to say a friend of mine. So, Craig, welcome to the show.
Thanks very much, guys. I really appreciate you having me on.
Yeah, this is the first time you've been on the show.
It is.
Craig, what got you into the 2A space? Let's get the listeners to learn a little more about who you are and
sure. So I was raised in a law enforcement family. I think I pulled my first trigger at about 4 or 5 years old.
Nice.
I've come from a family of educators as well. My mom and my whole mom's side of the family were formal educators, so that runs in my blood. So unofficially, I'd been working with people, teaching them how to be safe with firearms for a very long time, and then I was introduced to USCCA about five and a half years ago on the law side, on the legal side, and I guess they were pleased with some things I was doing. And they said, you know what, you got to meet this crazy guy from Pittsburgh who does training on the range. You might like to run around with him for a while. So, and I met you in a basically a Pistol 101 class, but yeah, and you encouraged me to incorporate and to make everything that I had been doing unofficially official, and kind of sponsored that dream. So I did right shortly thereafter, and been doing it ever since.
Yeah, Overwatch Armaments.
That's right.
And
yeah.
you got the storefront and the FFL and everything now.
Yeah, we've got a brick and mortar. I partnered with a real good guy named Chris Fox, who used to run a very well-known gun store here in Bucks County, Pennsylvania, and that's his every day. He does our brick and mortar gun sales. I run the training division. I get on the range as often as I can, and I'm in the classroom about once a week right now, teaching the legal use of deadly force and some of the other that's my curriculum, and then some of the other curriculum that's written by NRA and USCCA.
How long have you been practicing law?
This is my 26th year.
Wow.
26.
So were you like 5 then, right?
Yeah. I was 5.5 years old when I started.
Here's the clean living, right?
Yeah, it's a young face, yeah. Young face, young heart. I started in a prosecutor's office like a lot of litigators do, here in Bucks. Government work didn't suit me, or perhaps I didn't suit it. And I went out and opened my own business with my current business partner. My current business partner and I have been in business together on the legal side for the last 20 years.
Oh.
I'm a big fan of long-term relationships. So, and so he and I have been law partners for we just celebrated 20 years in March, and he focuses on the civil side, and I focus on the 2A and the criminal side.
It's awesome.
So how many criminal defenses have you done, like 2A
Thousands.
related?
Just it's the number. It's a big number over that period of time. I've spent. It's less these days because I'm trying to focus more on the homicide, the self-defense litigation, the attempted homicide, that kind of thing. And those cases are just big in nature. Most of them take hundreds, some of them take thousands of hours of work, and so by consequence, you get less of them. But yeah, I'm one of the individuals in Pennsylvania who's licensed to try a capital murder case. PA, for those that don't know, PA has a rule 801 that says that only certain experienced attorneys are allowed to defend an individual who's tried with murder under special circumstances, in which the prosecutor is seeking the death penalty. So I've done all a handful of those, but
Well, that's a good testament to you then, for sure.
yeah, it's this work sometimes takes a little bit out of you, but I think it's important work. I think it's important, not just for the people I'm defending, but for everybody, and
General
because
public.
without each of the players doing their jobs correctly and honestly, then the system doesn't work.
I think a lot of people forget that it's an affirmative defense in the sense that you're admitting to it. Yes, I did it in defense, and the DA, ADA, they're going to try to put bullet holes in that defense, and if they can crack it at all, that could make that jury believe that person actually did it and premeditated or minimum manslaughter. So a lot of
Yeah,
people.
yeah. Self-defense is you're really balancing on a wire without a net, because in most cases the government's obligation is to prove that the entire case happened, that the fellow was there or the gal was there, and that they did the thing that is alleged. Well, in a self-defense case, you can't very well argue in the alternative in a self-defense case. You can't say, ladies and gentlemen, my client was in Toledo, Ohio on the day when this killing occurred, with 30 witnesses, and I'm going to bring those witnesses in front of you. But if you find that he did it, it was self-defense. You just lose all credibility with your fact finder, and they instantly find your client guilty. So, you own it early. You say, yes, this killing occurred. Yes, it was an intentional killing. However, it fits one of the very narrow exceptions wherein that conduct is lawful,
Hmm.
or at least excused.
With the thought of the jury, and can you explain a little bit about the chit where you get to pick, you get to say I don't want this juror because of X reason or whatever, and the amount of jurors, 12 versus 6, civil, criminal, that kind of thing.
Sure, sure. So in Pennsylvania, all criminal juries, whether it's a murder or a retail theft, 12 jurors are required. The more complex the case, and that by that I simply mean the longer period of time it's likely to take to finish the thing. The more complex the case, the more alternates we carry. Just because if one or two or three people get sick in the middle of the trial or have an emergency of some kind,
That's true.
and you don't have enough alternates to fill a full 12-person roster, then it's a mistrial and you have to start the whole thing over again.
Hmm.
So yeah, it's all of our juries, of course, are unanimous. The verdict, whether it's guilty or not guilty, as to each individual criminal charge, has to be unanimous. In other words, all 12 people must say that the person is guilty of that offense, or all 12 people must say the person is not guilty of that offense. It's a little different in the capital realm, because once an individual is found guilty of first-degree murder, if the government is seeking the death penalty, then really a second trial begins. And the only question in that trial is what the punishment will be. Will it be life without the possibility of parole, or will it be death? One of the things that happens more often than you'd think is we forego a jury and try the case in front of a judge alone.
Yeah, I was going to ask you about that actually.
Yeah, I'm blessed. I happen to practice in most of my cases are in Bucks County, although I've tried murders all over Pennsylvania. But the volume of my cases here in Bucks, and in my career, I've been blessed to have been before an intellectual and fair set of judges. And on a number of occasions, I have waived the presence of a jury and tried murder trials in front of judges sitting alone. Um,
You'd only do that if you felt that judge was going to be, you know, impartial and fair.
Yeah, historically in this county, just if you look at the numbers, there's only been two occasions when a judge gave a defendant the death penalty when they had the decision to do so.
Hmm.
So it just almost never happens. Juries do it far more often.
Hmm.
Because the jury that decides life or death is the same jury that heard the case.
Mm,
So, they just got done finding this guy committed this heinous act.
Right.
yeah.
And now you're asking that same group of people
Mm,
to spare their life after, some of the worst things that you could imagine being heard have been in the courtroom. To that end, we usually try these cases in teams. We artificially split the case down the middle, and one attorney tries the guilt or innocence phase, and the other attorney tries the life or death phase if it gets to that. And the reason for that is so that the jury literally hears a different lawyer arguing for life, because if I did the guilt phase, they might hate me by the time we get done the case because the
Yeah.
client did it,
yeah.
and we get some emotional separation. And
Mm.
the new lawyer stands up and says, "We don't argue that you found him responsible. Now we want to talk about what happens next."
And it's interesting.
Hmm.
I served about 3 years ago. I served on a civil trial, and surprising that they kept me. They didn't boot me off, but it was a guy who was former military and security guard, so I guess they had that connection there with me. But also, I've had neck surgery from car accident, so he was suing his physical therapist for issue to his knee that he says she caused. Well, I've been in a car accident and I've gone to physical therapy, and right, so they figured, well, the other side figured, well, he's been to a physical therapist. So they both wanted me, they both kept me. I knew the judge. I mean, I've had lunch with the judge, so I'm thinking I'm going to get booted because of that, but that didn't come up as far as conflict. Yeah, so and then the jury, it was a 6-person jury. The other 5 voted me 4-person, which was kind of neat and an honor. And yeah, so it was a really neat experience, and I would definitely tell anybody, if you get the chance to do it, because we need more people like us
Yes.
on the
Yeah,
Yes.
jury.
100%. Yeah, I I've always wanted to be on a jury, whether it was civil or criminal, just to understand that
Aside,
that relationship and how that works. I, I I think there's a very small chance that I will ever see the inside of a deliberation room during deliberations. Anyway, I regularly try to talk to my juries after verdict, once the gates are open, so to speak, and we're allowed to
yeah,
speak, because
after the
we do
deliberation.
get some interesting verdicts. We do get some interesting answers from juries. And it helps me to do a better job.
Mhm.
Just because I said words doesn't mean that they heard those words or
Right.
that I said them in a particularly well stated fashion. So,
Yeah. Yeah. The judge actually, I texted him after and said, hey, Your Honor, it was great being in your courtroom. Keep up the good job. It was an honor to be there. And he said, can I call you? I was like, sure. So we talked for like an hour afterwards, just like, okay, what did that, why'd you do this? Why'd that happen? So it was really, really cool perspective to be able to see that. And he felt value in it. And then obviously it helps me and my students to be able to give them a firsthand, account.
yeah, yeah, it's
So,
it's a complicated process. Once all the due process happens, once I do have a client who was convicted of first degree murder. He was convicted of killing a 4-year-old child.
Oh,
And then he stabbed her pregnant mother to death, killing the mother and the unborn.
jeez.
And the jury gave that young man life for the mother, but gave him death for the child. And that deliberation, the fact that they didn't just do all of one thing, that they split the difference, and they gave rational reasons as to why. It just shows how much thought and emotion juries put into these cases. There's a lot going in to their jobs when they take it very seriously, I think.
Yeah,
And
absolutely.
but yeah, that of all my cases, that's the one that I'd love to get a mulligan on. I'd love to try that one again. But yep.
Yeah, I mean, you could just, come over the border illegally and say you're not a citizen. They probably put you in a jury, but that's another conversation. So, question for you on this. We talked about I went down a rabbit hole, I know.
That's right.
You talked a little bit about a hung jury, so having a mistrial. Usually, what I'll tell my students, and I want to get your take on this. If you get a jury of 12 in New York, it's 12 and 6, so 12 for felony, 6 for misdemeanor, 6 for civil trial.
Mhm.
So if you got 12 in a criminal trial, felonious act, and 11 of them find you innocent and one finds you guilty, it's a mistrial, it's a hung jury.
Right.
The chances of that DA, and this is kind of where I was thinking, the chance of that DA retrying that's pretty low. I mean, they could, but I mean, really, would they if they really think it was that one-sided?
Yeah, we don't often get the number in
Oh,
PA.
hmm,
We don't often know whether it was 10 to 2 or 11 to 1 or
okay.
they just, the judge encouraged, they say, we're deadlocked. The judge encourages them a couple of times to go out and continue deliberations. And then when they finally say, you know what, we're going to punch each other in the throat back here, and the judge finally cuts them loose. We don't often get a lot of data on that.
Okay.
What's interesting, I try a lot of cases. I'm in trial almost all the time. I've only ever had one mistrial in my entire career,
Wow.
Wow.
and it was for a DUI case.
Hmm.
Hmm.
So not an unimportant case, but certainly a little pedestrian compared to some of the other stuff that I do. And we the judge dismissed us and encouraged us to come back the next day and start the whole thing over again. And there was an evidentiary revelation at about midnight that night. Both the DA and I found a piece of evidence that we had both overlooked throughout the course of preparations for whatever reason. And we texted each other almost simultaneously. Her asking me what time we would be doing the guilty plea the next morning, and me asking how good the offer was going to be. So it actually, even though it was a mistrial, it actually didn't even end up being a second trial. I've never tried the same case twice.
Wow. You just alluded to evidentiary hearings, so the pretrial hearing. Can you elaborate on that a little bit as far as like what goes on, what evidence is presented to be the judge decides if it's going to be entered as evidence or not.
Yeah, yeah. So I'll split it in two halves. The first being just kind of an ordinary case, and the second being a death penalty case. Um, in ordinary case, especially if it's a possessory crime, the possession of an illegal item, a stolen firearm, a stolen car, or a contraband like narcotics, something that you're never allowed to have. The entirety of the case is pretrial. Because if they get the evidence in, it's not all that difficult to show that they had it in their pocket or that they were behind the wheel of it. So the trick in those cases is to suggest that the government, by the manner in which they investigated the case, it broke some law, did not follow some procedure, such that it's necessary for the evidence to be suppressed or thrown out before the case begins.
Fruit of the
It's
poisonous tree.
right. It's exceedingly difficult for the government to move forward when they don't have the illegal item itself to talk about. So in the capital case, pretrial arguments themselves can take a week, because we attack not only all of the evidence in the case, but we attack the proceeding itself. Every time a district attorney tries to invoke the death penalty, we challenge the death penalty again. No matter how many times before a court has said, this statute is constitutional, this statute is going to stay where it is, every single one of those cases in every county, everywhere in Pennsylvania, the defense attorneys are trained to re-challenge the constitutionality of the statute. And we do this because, in states like New Jersey or Florida or places that have gotten rid of the death penalty, there was one case that changed it. And you're hoping that you're that case, and I do the same thing when I'm practicing Second Amendment law. I there's the
Look at
box.
look at the
Second,
Bruin decision.
sure, sure. I mean, there's
Yeah.
there right, exactly, right. We have superior or trial court judges and superior court judges screaming at us that this isn't going to work, this isn't going to work, and you just keep doing it until
Yeah.
somebody listens to you or the landscape changes and you get a more favorable court that changes their mind.
On that, if there's stuff going up to the Supreme Court and they grant writ of certiorari, when something like that happens, that's usually has to be rifts between different districts in the Supreme Court, right? So if it's California says magazines, this person that got arrested with a magazine, that's illegal. The New York jury says no, that's legal, and then it appeals, and then the appeals court says, difference, and then that would be might be and once again, the Supreme Court's the only court in the entire United States that doesn't have to take a case. Then they might grant it writ of certiorari to be able to hear arguments or right? Is that
Yeah, yeah.
basically the
Oh,
gist?
well, one slight modification. Each state has its own Supreme Court as well. They
Mhm.
also are with one or two minor exceptions, are courts that can or cannot take a case at their discretion. In Pennsylvania, since we were on the topic, an individual who has received a death sentence, their case is automatically reviewed by that state Supreme Court. So that's one instance where, or when a writ is filed, a request for a writ is filed, it is always granted. But yeah, 100%. When it relates to the federal Supremes, we know that they pick those cases which they want to hear, which they think is and I'll be honest, this court that we have sitting right now, what they're choosing to hear, and maybe more importantly, what they're not choosing to hear, really has us scratching our head.
Mhm.
Um, there's a lot of issues out there that I think that not just those of us in the industry, but people that are even moderately interested in the Second Amendment or would think, what, we need to confront some of these issues and put them to rest and not getting hurt.
I find that interesting too, Matt. You obviously have a wide breadth of knowledge about the courts, and I'm surprised that New York even allows people to have a jury.
Yeah, right. For sure. Well, it's like the
Hey, to be on a jury in New York, do you have to take a test and get a license?
so no, but one of the
18-hour
late
course.
yeah, right. One of the ladies actually said, like, well, I don't know if I could find her guilty because she looks a lot like my granddaughter.
Well,
And
see, that's why you might want the bench trial sometimes, because
yeah,
it's in theory the bench trial removes the emotion out of it, right?
Yeah,
yeah, could
yeah. So there's lots of reasons why we go bench, right? And one of them is to try to remove bias.
hmm
If you have an individual where the case is just loaded with bias, whether it's age or gender or race or national origin or whatever it might be, jurors lie to me every day during jury selection. We hand out, I don't know what they do in New York, Matt, but in PA we do a questionnaire where the jury in the jury lounge before they ever meet me, they fill out a questionnaire that has about 25 or 30 questions on it.
we did that.
And some of those questions are things like, would you be more likely to believe a police officer just because they're a police officer? My father was a police officer for a very, very long time. I might be tempted to check yes to that box. He was a very dear person in my life. But then they receive an instruction from the judge saying that's not permitted, and then their answers change. And you have to wonder to yourself, did their answer really change, or are they saying that because the judge told them that it had to? So
Right.
you get kind of a candid glimpse into the minds or hearts of these jurors when they fill out the questionnaire, and then when they sit before the man or stand before the man, as it were, their answers change, and you know you have to decide whether that was an honest change of heart or whether they're just saying what they're supposed to say in front of the person in the black dress.
Hmm.
Sure. It was interesting how much respect at least in my court appearances that I was in as a juror, but how much respect the judge gave to the jury. Like the judge was standing and the jury comes in, and once we sat down, the judge sat down, and I was like, wow, that's it just shows you that the judge is there to preside over both sides and is the highest person in the room, but in a sense, it's the jury's making the decisions. So it
Yeah,
was kind of humbling and neat to see.
yeah, yeah. And again, I think it matters on how long they're planning on being there. I've had juries that were with me for 8 hours, and I've
Mhm.
had juries that have been with me for almost a month. And when you're pulling that kind of time away from a person, from their family, from their job, and they're getting, whatever it is, $12 a day to be there, you do really have to tip your cap, because they invest themselves in the process, and they care about it, I think, as we would if we were seated on a jury and asked to do an important civic duty.
For sure.
When Masad Ayub was on our show years ago, he had talked about different situations where in certain cases where like modifications to someone's carry gun and all that stuff became an issue for the defendant. Obviously, people can screw things up when they say something wrong or something silly or something that could, be incorrect because of their memory. So anything said can be an issue. But have you ever encountered any times in any of the trials that you have dealt with where someone did make a modification to a carry gun or something equipment related that really, really hurt them and made your life hard to defend them?
Yeah, prosecutors are probably a lot like some litigators we know. They don't know a whole lot about the science techie stuff on the gun. They just know that it's the instrument that caused the injury,
Mhm.
and they don't often think, and they end up having to. They actually, in my county, they send DAs to school to learn about guns. They might actually even shoot one once. But it's not often, unless a detective or an expert tells the DA that a modification has happened, that they even know about it.
Hmm.
But yeah, they are latching on to modifications. I think with the forced resets, I think with some of the other open questions that we have right now. I think if you're making your gun, to use the government's words, more dangerous, if that's a thing, I think they're going to latch onto that. I'm now seeing them prosecute based on a theory that they're calling overkill,
Mm.
which simply means how many rounds were fired.
You can shoot too fast.
Yeah, I had a DA one time tell me, Craig, we think this was a lawful and justified defense of shooting, and if you'd only shot him once or twice, we wouldn't have a problem with it. But your client, emptied his magazine and hit the guy 6 times in the process.
In something like that, that's where you'd bring a subject matter expert in to talk to stress and emotion and such, right? And
Yeah,
when you shoot
Response
until the
time and
threats, yeah,
right.
shoot until
yeah,
the threat's no longer a threat, and be the same thing as somebody who was shot in the back as they're falling and they got shot.
yep. And then it becomes, a money question.
Hmm.
Um, when I try these cases, especially the murders, I might be appointed by the court. And then every dollar that I want to spend, I have to go to my judge and beg for it.
Wow.
I tried a case, it was a cold case last year or year before last, I guess it was, of some renown. It would end up on Dateline for whatever that's worth. And
Nice. That's awesome.
it took the government 30 years to catch this guy.
Wow.
They spent around $6 million in the course of their investigation. And I was cut a check for expenses of about $2,500. That was my budget to defend that guy.
Wow.
Wow.
And listen, we put a hell of a show on for $2,500, but that so there's an inequity there. You're talking about subject matter experts. Yeah, I've got a list of ones I would love to call someday. And one of the nice things that happens when I work with organizations that fund defenses is money's not an issue. I get to be the 800-pound gorilla in the room and call that guy who's going to say, you know what, responsive reaction time after having perceived a change in circumstances is this long, and how many shots are fired in that duration of delay, and to start explain this rapid fire or this spray of fire, in an innocent and non-nefarious way. So, but yeah, no, the CSI thing is a thing. The government has a lot of money to convict people with, and I don't.
That's another reason why USCCA membership's a pretty damn good idea.
Yes.
Yeah, I've spent more defending USCCA clients on non-murder cases than I have spent defending non-USCCA clients on murder cases.
Wow. What would be like if somebody came to you and they had a lot of money and they defended themselves? What would be a window of like entry attorney, not not your basic public defender, but like entry attorney that's good up to somebody who's like yourself, like really good at the job. How much would they look to be paying for a retainer just to look at the case?
Um, are we talking about a murder case, Matt? Or are we
Yeah.
talking
Yeah,
about,
I would say,
yeah,
but give two categories. One would be a self-defense where the person survived,
yep.
and then the other one would be the person expired, unalived.
Yeah, so most criminal defense attorneys don't charge for the consultation.
Okay.
We'll take a look at the case. We'll talk to the client a bit. We will take a look at the complaint. The complaints on those are usually a small book, and just get a sense for what the case is and the direction it's likely headed.
And just so people know that the complaint is the formal paperwork that the DA's office and the law enforcement put forward for the felony act that was
Correct. Correct. A short explanation of what they are alleging has occurred.
correct.
And then most competent defense attorneys bill on a flat fee basis. So it's not if you get a divorce, maybe it's $200 or $400 an hour for however long the thing takes. I've never done that one time in my career. I give a number. That number is the number, and it doesn't change absent anything. So, and that needs to be paid up front. The reason I do it that way is this. Very early in my career, I got into a case where my fee was covered, but there was nothing left after that. And I ended up spending what ended up being my earned fee to hire the experts in the case that were necessary because there was nothing left. So, you need a war chest for these things, and it has to be built into the case. So Matt, to answer your question, a responsible fee for a murder trial, I would think the entry level would be about 50,000.
Okay.
The last capital case that I did, my walk through the door number was around $250,000, and that ended up being about half of what was needed.
Wow.
Yeah, people don't realize how expensive that financial and legal damage is.
Yeah, and when you I stopped doing the math on what I was making hourly because it made me want to go get a different job. Because when you bill or when you work in flat fees, you don't run a clock. You don't keep track of your time. But once in a while I will. And I think the last death penalty case that I tried, I made about $38 an hour. Just because it's just so much darn work.
Yeah.
Well, I mean, your research and getting your papers together and like what's the workflow?
Yeah. So a lot of the workflow is human contact. The every time I do a case of any kind, my work is subject to review. In other words, somebody comes to me for a DUI case and they are convicted. It's entirely possible that both the trial court that heard the case and the superior court, and I guess under some circumstances it could be the Supreme Court, might look at the job that I did to determine whether it was adequate under the circumstances. Now, that would almost never happen in a DUI case, but it happens in almost every murder or attempted murder case. Because quite frankly, there has to be checks and balances to make sure that the attorney who was doing the defense did the job the right way. I mean, it's the most serious kind of case that we have.
Right.
And so in PA, it's called a Post-Conviction Relief Act motion, a PCRA. I handle the big bad guys, and so I build into my brain the reality that at some point in time, I'm going to be testifying about why I did what I did and why I didn't do what I didn't do in defense of this person. because somebody's going to ask me that question.
Can you a bunch more questions or thoughts here. So going back to the retainer aspect of it. So what I used to say, and I might augment this a little bit, and of course this is different across the country with different attorneys, different jurisdictions, but I used to say you're looking at $5,000 to $10,000 for them to just look at it. I've heard some attorneys say that they won't even look at the case unless there's some money up front to prove that the person actually can pay the bill. And then if it goes to trial, then I was saying well over $100,000 for the case. And then if it gets appealed, if it goes to other courts, higher courts, or depending on the severity of it, you're looking at millions. If it becomes a national case like George Zimmerman, like Trayvon,
Sure.
like Kyle Rittenhouse, et cetera, millions of dollars for something like that.
Sure. In PA, I'll split it down the middle between being privately retained and being appointed by the court.
Mm-hmm.
If I am appointed by the court, my job, I represent that person all the way through discretionary appeal, which is the state Supreme Court. So I'm doing the pretrial work, I'm doing the trial work, and I'm doing the post-trial work. I'm locked into that, absent some extraordinary circumstance. And I know I've done that work in more than one jurisdiction. Our sister county next to us pays hourly to the attorneys who take those cases.
Wow.
Bucks County has it on a flat contract rate. So it really does, to your point, Matt, it depends on where your feet are, what chair you're sitting in and where, because every county, I mean, I live in one of the wealthier counties in Pennsylvania, maybe in Eastern United States. And, they don't have a budget for this stuff. It doesn't exist. We're stealing from somebody else's kitty to defend these cases. It's been a journey, guys. It's you both know me personally. I'm in my private life, I'm a really conservative person. I hold those values dear to me. And yet I think that the death penalty doesn't have a place in our society for a couple of reasons. One, we screw up all the time. Like you ever heard the phrase, if you enjoy sausage or hot dogs, you probably never watch it being made.
Right.
And the law is the same way. I see how just terrible a job people do in the private and in the government sector, and it's frightening. And it's the capital punishment is, even if we used it, is the one thing that we can't unring that bell. That's not the soapbox on which I stand. I'm a libertarian at heart. I don't trust the government to do the right thing with my tax money. Why would I give them the authority to kill me?
Yeah, well, that's valid. I mean, and even at the beginning stages of a law enforcement officer showing up, me being a part-time police officer, I see it there, talking to one officer and the officer says, nah. And then another officer says, no, I'm going to throw the book at him. And we had one guy in our PD, he would, he'd pull somebody over 15 tickets, he'd only give him 14. He called that a deal.
A soft day, right? Yeah.
Yeah, it's like, oh, I gave you a deal, I only gave you 14. I could have given you 15. Right. So, and then you got other guys who don't want to pull anybody over at all. They just want to be there in case an emergency happens, and maybe not even that. So yeah, there's shitty people in all different walks of life.
Yep.
And
like you said too, I mean, it doesn't matter who you are, people make mistakes.
Yeah, absolutely.
And professionals make mistakes in whatever profession they're in. And yeah, that's like you said, you can't unring that bell.
Right.
Interesting.
Pennsylvania's had the death penalty off again, on again a couple of times in its history. We don't use it. The last person that Pennsylvania executed was Gary Heidnik, and that was the early 70s. So we're spending cumulatively tens of millions of dollars on a program that we don't touch. We don't use it. We don't even pretend to use it. We've had a moratorium on it in Pennsylvania since Governor Wolf signed it in his first go round. So we have district attorneys invoking the death penalty, knowing full well that it will absolutely never be used.
Imagine that. There's something in the government that wastes millions and millions of dollars.
Yeah.
Right.
Go figure.
I bet that occurs more than once too.
Yeah, I thought I'd kick that can over and see what jumped out of it with you guys. Yeah.
Yeah.
With
There's a lot of boat anchors in the Commonwealth, that's for sure, like the pit
Certainly.
system.
with
Yes.
um with the different layers of the onion, if you will. I after interviewing George Zimmerman, I came up with a term, the four horses of your apocalypse: criminal, civil, mental, and jury public opinion. And I try to get across to my students that it's more than just the criminal aspect, because everybody's, oh, I'd rather be tried by 12 and carried by 6. I'm like, how about we don't have either?
Yeah.
How about we don't, how about we make good choices so we don't end up in court at all? Because I've been court officer, police officer, and I've been on a jury. You don't want to have any of that.
Yeah.
You don't want to be in that realm at all. So why don't we not go to court? Why don't we not go to the grave? Why don't we make good decisions so we don't have to be in an argument or fight with somebody? Because even if we are justified criminally and they're not charged, we still could be sued civilly, because anybody can
Yeah.
sue anybody civilly. It's a different court. And then the jury public opinion is going to think you're a dirtbag, depending on, race, or it's a woman and you're a man. All that stuff can come into play. Or you miss them and hit a kid. And then you got the whole aspect of, well, criminal, civil, mental, you're sleeping at night and being able to, live through watching somebody's head explode like a piñata. I mean, it's not worth it.
Well, people typically don't recognize those other damages aside
No.
from, the physical one, and that's why they have the gun and trained to shoot really well at paper targets and stuff. But one common misconception is people think, yeah, innocent until proven guilty. Well, not in a self-defense trial. Like, the burden of proof is on you and on your team, as Craig said earlier. So I think this episode is going to be really educational for folks, and I actually look forward to sharing it with a lot of my instructors that I work with, because I think they'll find value in it. But outside of the legal stuff, because I know, Craig, you 20 years with this practice, and 20, how many years did you say? And you've been doing the legal
Yeah,
thing?
so I had 5 years as a prosecutor, and the balance of my practice has been defense.
Okay, so you're probably reaching a point in time where you might be able to start weaning out of this and somewhat retiring and getting more into the training aspect of it, right?
Yeah, I mean, listen, I don't want to I don't want to complain about a career that's raised my kids, but
Yeah, yeah.
this is a job that takes something from you, just like law enforcement. It takes something from you some days and doesn't give it back.
Yep.
So I want to stop doing this work while I'm still young enough to remember what it was like before I started doing this work.
Well, you at least look like you're young enough. That's so
Appreciate
that's better than Matt and I have. Well, Matt, you look younger too. Yeah. Yeah. Yeah.
Ish.
Yeah, I'd love to get away from the defense work. But every time I sit down with the books, it turns out I make a lot of money doing it, and people keep asking me to do it. So as long as that happens, and I'll probably stay.
Well, and there's you have helped a lot of people in horrible situations, and I think that's something too that I'm sure you hang your hat on as well.
Yeah. There's those days that are, you feel it back. Probably like a good educator, where that student comes up and tells you back something that you said that that it hit them in a certain way. And I've certainly, even on mundane cases, help people out of really bad situations.
So what's new? What's next for Overwatch? Or how about I say this? What's next for Trigger Pressers Union Local Number 3?
There you go.
When that happen?
Yeah, we made that announcement. Well, we kept it kind of quiet. We didn't make too big of an announcement, but
awesome.
Yeah, he's the union boss for Trigger Pressers Union Local Number 3.
Love it.
Yeah. So all new curriculum is it. USCCA has some new curriculum coming out this year, I think, and I'm interested to see how that works. I'm a big fan of Pincus, and I like to teach his material. I think it makes a lot of sense to me, and I intend to hopefully work with you in the PDN tour, and I'd love to get back on range with Pincus and listen to him. And I think there's a question that has to be answered about any time we train, and that is what we're training our students to do defensible in court.
Yes,
absolutely.
In other words, is a quick draw time a good idea or a bad idea? It might save your life, but what happens when somebody asks about your 10,000 hours of training on getting it out of the bucket and into the air? is there a negative to any part of what we do when it comes to how it will be reviewed, to Matt's point, in the public opinion or in the legal realm. And so that's the street that I'm driving down right now. I'm trying to look at everything that Trigger Pressers teaches, that Overwatch teaches, that USCCA teaches, and frankly, some of the people that teach things that I don't agree with, and and see where they rise and fall within the realm of a self-defense shooting on the legal side.
Yeah, that's awesome. We're doing
Yeah, it
a
is.
we're doing an instructor development class in October for Trigger Pressers Union, and I'll be doing that out there at Craig's place. And I had asked him to put together a module for that instructor development that talks about what we teach. Is it court defensible? You know, the things that we recommend people say or recommend they don't say, is it court defensible? And even
Awesome.
recommending something like that, is that court defensible too? So I really appreciate the work you're putting into that, and that's going to be a really awesome module. But that's something definitely I really I really didn't wholly understand that concept until we did that Masad Ayub class when we hosted him, and that was a game changer for me.
Same.
Like, wow, okay, my well-intended statement here that I would give students, like, I know why I said it and I meant well by it, but actually if they repeated that and they did X, Y, or Z, that could get them jacked up in court.
Yep.
I need to stop saying that.
Yeah, one of the biggest falling downs of the USCCA curriculum is that they flat out encourage members to make a scripted statement upon being confronted by law enforcement. Think about that scenario. You've just done a thing that you deem to be necessary to live.
Yep.
It doesn't feel like an evil thing in that moment. It feels necessary. And we might be inclined to talk about it in a way that we shouldn't. I mean, I've written lots and lots of employment contracts and union contracts for police departments, and we always give them that 72-hour period of time in which, if they've discharged their firearm in the course of their duties, they have to cool off before they have to give their first written, verbal, or recorded statement. And that's just because of how terrible our brain is to us when we encounter those scenarios.
Yep.
Under absolutely no circumstances should any words of any kind come out of your mouth if you kill someone in an act of self-defense. In every jurisdiction that I'm aware of, a citizen has exactly one obligation when confronted by law enforcement, and that is to identify themselves. That can be done by producing government-issued identification. You don't have to say any words. You can throw them your driver's license. Once we start talking, I mean, I live in the town where my dad was the police chief for a very long time. Half the cops on the force have had dinner at my house.
Nice.
I might be very inclined to explain to them why I did what I did. I don't think I've ever lost a murder case where my client's own words weren't the thing that convicted them. So it's just really important to shut up.
Well, we have, I mean, like you alluded to, we got false memories, we've got, lost memories, we've got, we see a color, you see a different color. I mean, there's just so many variations that could, I'll tell people, if you're going to tell somebody if you're going to ID somebody, because we're going to do a bolo, be on the lookout for when as a police officer, we're going to look for this bad guy, what information would you want to give? And they're like, oh, their height. I'm like, how do you know their height? I mean, you're going to say they're 6 foot tall? And that's going to be, that's perfect, ammo for the defense for that person. Because, well, my client's 6'1", so
right.
Yeah.
So, it turns out humans are terrible historians.
Yes.
Oh yeah.
Yeah, exactly.
Heck, I probably won't remember half of the conversation we're having now, and I'm completely lucid under
Right.
no stress, and then I'll watch the recording.
So
and go, oh yeah, that's right.
That's that age thing coming back in.
Yeah, maybe. I don't know.
For sure.
I don't know. Even when I was younger, it took me a long time to remember what my wife's name was, actually. So
yeah, but you can remember full movies and every word said in a movie.
Right. See, that's it. All of my smarts have been overtaken by lyrics and dialogue.
The file cabinet's full.
Yeah,
That's hilarious.
Yeah, definitely.
But yeah, no, that's the one thing that I think I lecture on that, and I get a lot of pushback from students, because they've heard over and over and over again what to say and how to say it, or perhaps request an ambulance immediately, so that you're taken to the hospital instead of making a statement to police. Well, the police are going with you in the ambulance, so that's not going to
Yeah.
help. And if
Right.
you didn't actually have a medical necessity that
Like,
would have required an ambulance, well, now you're just making stuff up, and
yep.
that has that you're maybe you were perfectly correct in what you did, but your actions are now suspect because you're conducting yourself in a way that isn't genuine.
Yeah. I'll say the first person to call 911 is typically the victim. And the Bible says evil will flee. So unless you have to flee the scene for your safety, or you're instructed to by law enforcement or dispatch, stay there, because it's going to make it look like you fled the scene of a crime you committed.
There's a great deal more to it than putting holes in pieces of paper on the range, and
Certainly.
Absolutely.
that's definitely something that I think the three of us agree with. And even just having this conversation we're having right now while you're on the range and you just shot some targets and you did some exercises, I think is going to better equip our students with the ability to survive that legal aftermath, in theory, anyhow.
If you shoot somebody in self-defense, what's your thoughts on providing medical to them?
I think that's less of a legal question, more of a moral one.
Okay.
Um, I would love to believe that if I've rendered the threat inert, such that my life and my family's life is no longer in danger,
Mhm.
and I could save an individual, that I would do so,
Okay.
with whatever rudimentary first aid skills I have. Um, Whether in practice, coming down off that mountain, so to speak, that high that I had from all that endorphin dump and
Yep.
chemical neurochemical dump that I got, whether I would physically be able to, whether I would be able to reach into my soul and do that for the person that just tried to kill my spouse or my child, I don't know. I hope I do. I think it's a wonderful thing for those people. I see acts of forgiveness in courtrooms all the time.
Mm.
Some of the most
Hmm.
powerful things I've ever seen. Grown men forgiving the man that killed their child. It's
Wow.
extraordinary. I hope that I have that level of compassion in me, such that I could help an individual in need, and not just somebody on the street, but somebody who tried to do me harm. From a legal perspective, there's absolutely no requirement that we pitch in and try to save somebody. That's not a thing that we have to worry about. It's more of a, is it safe to do so, and do you have the ability, the moral ability to do it under those circumstances? Most crimes of violence are not committed by solo actors. Particularly in today's world, most cases that I see now, especially in planned acts of violence, but all of them, you've got more than one bad actor. Now,
Dirtbags run in packs.
yeah, we all hope that the other bad guys flee when they hear your shots. But if they didn't, just because this threat is no longer a threat doesn't mean you're safe.
Mm-hmm.
Hmm.
And putting your guard down to the extent where I'm kind of visually, I'm picturing right now kneeling beside someone to render aid.
Right. Gun
That's
back in the holster, and yeah.
Yeah, that's a
Right.
precarious position to be in.
Yeah.
For sure.
When the scene was one in which you just barely survived.
Hmm.
Yeah. Well,
Very well. Very
kind
well
of
said.
what Craig said before. That's there's your moral damage, right? So if can you live with yourself, and maybe you can. Maybe you can reconcile that and say, "Hey, I kept myself and my family safe, and the bad guy expired, and I'm okay with that because my family and I are safe." But
Mhm.
if you're someone that would second guess your decisions for the rest of your life because you didn't help render aid, then that's one of those, that's the damage that we have to deal with. These are good conversations to have, because if at least we talk about them and we start to think about them now, in theory we're better able to deal with those in real life, if it ever were to be a thing.
One of the things that I took away from your less lethal class, non-lethal class the other month, was, I have an entire section of my student body that will never carry a gun.
Mhm.
They either don't have the moral constitution to do so, or specifically don't want to. Does that mean that they should be disarmed or unable to defend themselves should the need arise? And of course, the answer to that is no. And that's that stopgap measure, right? That's that allowing people to get to midnight every night safely, and not carry around that moral burden of knowing that if they have to act, they'll kill somebody.
Yeah.
So
How can Go ahead.
No, go ahead. You like saying this because you're good at this.
Yeah,
So
I
go
was just
ahead
gonna
and
say.
say it.
So how can people check you out and give them your business?
Yeah, so if they're in the Philadelphia suburban area, specifically north of Philly, my brick and mortar is in Dublin, Pennsylvania. We'd love them to stop by Overwatch Armaments and check out our inventory and our storefront. But they can always go to overwatcharmaments.com and check out my training schedule and learn a little bit more about us.
Cool. Excellent. Well, I'm really glad you made it to the show.
Likewise.
Thank you for having me.
And we'll make sure this occurs more often. And I look forward to the work we're going to do together moving forward with Trigger Pressers Union.
Yeah, me too.
So excellent. So Matt, you want to officially call it off? I have a motion to adjourn. You got a second? All in favor of adjourning, signify by saying aye. Aye. Any opposed? All right. Well, there. That was how we ended this episode. So we'll see you guys next time on Meet the Pressers on the YouTube, on the Facebook. We're all over the place.
Yep. Can't stop us. Stay safe.
Thanks very much, guys.
Lots of sponsors that make this show possible, like Mantis, Next Level Training.
Check them out and give them your business.
Meet the Pressers is brought to you by Mantis. Mantis X helps shooters suck less. Next Level Training, makers of CERT training products. Meet the Pressers is also brought to you by these fine companies, shows, organizations, and our Patreon members. Thank you.
Thanks for watching the show.
Make sure you like, subscribe, share, and click that little bell thingy so you know when the next episode's coming out. Support us on Patreon. Come to one of our classes. Host us to come to you and do one of our classes at your location.
And until next time,
adieu.
Thank you for watching Meet the Pressers.
Lots of sponsors that make this show possible, like Mantis, Next Level Training.
check them out and give them your business.
Meet the Pressers is brought to you by Mantis. Mantis X helps shooters suck less. Next Level Training, makers of CERT training products. Meet the Pressers is also brought to you by these fine companies, shows, organizations, and our Patreon members. Thank you.
Thanks for watching the show.
Make sure you like, subscribe, share, and click that little bell thingy so you know when the next episode's coming out. Support us on Patreon. Come to one of our classes. Host us to come to you and do one of our classes at your location.
And until next time,
Adieu.
Thank you for watching Meet the Pressers.